All right. Thank you for joining us for Mountain States Legal Foundation's latest in our series of webinars. Mountain States Legal Foundation was founded in 1977. We are a public interest legal foundation focusing on individual liberty, the right to own and use property, limited government, and the free enterprise system. If you want to learn more about our cases, you can visit us at mslegal.org. Or you can follow us on any of our many social media accounts. We have Facebook and Twitter, where we'll update you regularly about our cases. So this webinar is going to be a little bit different than some of our others, and thank you for joining us for it. We actually have, as you'll see, I'm Cody Wisniewski. I'm one of the attorneys here at Mountain States Legal Foundation.
I'm David McDonald. I'm another one of the attorneys here at Mountain States.
And I'm Gregg. I'm also an attorney.
That's right. You have a panel of 3 attorneys sitting at one table, and there's no boss in sight, which means we're going to go ahead and dig in to some of the interesting cases that the Supreme Court has looked at this term. We're going to look at their denials. We're going to look at some of the cases that they issued opinions in, and we're going to walk through with a panel of attorneys kind of our interpretations and our takeaways from this term. So we're going to go ahead and start with the denials. And there's going to be 3 kind of major categories of denials. One's a specific case. The others are categories that we're going to talk about. And for me personally, I think that these denials actually speak a lot more to the future of the court that we're going to see than a lot of the major opinions that people have been looking at will. So the first of those is the broad denial of the 10 pending Second Amendment cases that were before the Supreme Court. We've talked about this before on one of Mountain States' previous webinars, so I won't dig into it too much. But basically, New York State Rifle and Pistol Association was a case that the Supreme Court granted certiorari in early last year. And that means that they had agreed to review the merits of the actual case. That's relevant because it's the first case that the Supreme Court had done that in since the McDonald case that was issued in 2010. So those of us that are Second Amendment advocates, gun rights advocates, had been waiting for this moment for a long time. And then there were a number of interceding procedures, and eventually the case got mooted out. And in April, the Supreme Court ruled that the case was moot, but there were a number of justices that filed dissents. Justice Kavanaugh filed a concurrence, and what he said was, we're going to really need to revisit this issue soon. And as soon as we saw that, most of those of us in the world kind of thought, well, that means they're going to take the next Second Amendment case that comes before them. And immediately after, they had relisted a number of Second Amendment cases that were pending before the court. Basically, what that means is the Supreme Court was looking at these Second Amendment cases very closely. And then in a bulk decision, just denied cert in all of them. And really what that said to us is, what is the court doing? Why is the court not addressing this issue? There's a lot of variance at the lower courts in these interpretations. So what my major takeaway from the Second Amendment denials is the court just isn't going to weigh in on this question anytime soon. And it seems like neither the 4 progressive leaning justices nor the 4 more traditionally conservative leaning justices are confident where Chief Justice Roberts is going to come out on the issue. And to me, that's the only thing that made sense. And that's all I can really see being the case. So what this denial really says for the future of the court is, the second look at the Second Amendment practice is going to be a little bit differently. And as Mountain States, looks at these cases in the future, we're going to treat them just a little bit differently, knowing that the Supreme Court probably isn't going to grant cert.
Yeah. And I'm curious what your perspective is on the insights we've gotten from, if any of you are not aware, over the last few days, CNN has been publishing a series of exposés on leaks from the Supreme Court this term, centering largely around the actions of John Roberts. I'm curious what your takeaway from that is.
Yeah, so reading the article, what it basically said, what the leak had essentially said, and I don't know the veracity of it, obviously, I'm reading the same news stories that you guys are, was that, the 4 conservative leaning justices, it seems like Roberts wasn't going to vote with them. And that kind of falls along the line of what my interpretation was right after, because we had opinions from those 4 conservative leaning justices that had all talked about the need to address Second Amendment, and Roberts was really the only silent party. So I think that leak in particular, again, I don't know the veracity of it, but seems to kind of fall along with what my opinion was. But I don't want to stick on Second Amendment too long. If I did, we would be here for an hour just talking about that. David, why don't you talk about the qualified immunity cases?
Yeah, so this is another situation that's really similar to the Second Amendment situation where there were a lot, I think for the qualified immunity case, I think there were 8 or 9 qualified immunity cases up before the court that they were deciding whether or not to take or not. And usually when we see this situation where the court takes like 7, 8, 9, 10 for the case of the Second Amendment cases, that's usually because they've already decided they want to deal with that issue and they're just trying to figure out the exact right factual scenario they want to use. So when we saw that the court had 8, 9, I forget the qualified immunity cases, how many of them on their docket, we thought, okay, this is going to be a new thing court's doing. For those who are not aware, qualified immunity basically means that government officials, particularly police officers, when you sue them for constitutional violations, they basically can't be sued at all. The courts have held them to be immune from suit because it's not fair to hold them accountable for what the law says, like ordinary citizens. Now, this was less surprising than the Second Amendment cases because the court has not given any significant indication that is willing to revisit its qualified immunity jurisprudence. We've gotten a lot of lone dissents from Justice Thomas talking about how the doctrine does not have any sort of purchase in the original text of the Constitution. But the court has been largely bad on this. But I think a lot of us in the movement who are following the court allowed us to get a little too excited, assuming that the tides of the zeitgeist in the society were finally moving in a place that the court would have to act. Because again, this is an area just like a Second Amendment law where the lower courts have just been incredibly inconsistent in how they apply it. And we were really waiting on the Supreme Court to give us an answer and we just didn't get one.
I thought there was a really interesting case coming out of the Ninth Circuit dealing with qualified immunity. I think you wrote an article about it where the Ninth Circuit basically said that the police officers in that case couldn't know that theft was unconstitutional. And the circuit called it theft. And I thought, if nothing else, that the Supreme Court would tangle with kind of the factual scenario of that. My takeaway from these denials was that, even though we seemed to think, or we thought that, public opinion, the current culture might shift the court and might pressure the court into taking one of these cases, the Supreme Court told us that's how they work and denied all of them.
To the point where, and this actually makes me think, is maybe we need to rethink what a large number of cases on the court's docket means. In this case, because the fact that the court has largely been fairly consistent in how they feel about qualified immunity, this might actually be taken as a sign of, oh no, every single possible permutation of this question we're denying. So I think we might in the future start seeing these types of cases as more of a, oh no, we want to be emphatically clear here. Stop sending us these cases.
That is an interesting takeaway. I haven't thought about it that way. I, for the future of Second Amendment law at the Supreme Court, hope that you're wrong. But there are still plenty of other courts to be litigating in and plenty of other issues. So it just changes the way that we look at these issues. But getting away from these bulk denials, why don't we look at one of the most recent denials that we saw dealing with the Nevada church? And this was coming out of the COVID scenario. So Brian, do you want to talk about that?
You bet. The case is called Calvary Chapel v. Sisolak. Like Cody said, it's from Nevada, and it concerns the restrictions put in place by the state of Nevada concerning houses of worship, churches, synagogues, mosques, that kind of a thing, concerning the coronavirus. And the general rule for religious buildings, like, anything from a casino to a bar and restaurant, a movie theater, what have you, the general rule there in Nevada is that you can only go up to 50% capacity. Okay, fine. But at a place like Caesar's Palace or the Bellagio, that could still be thousands and thousands of people. Now, what was different in Nevada with houses of worship was that there was a strict cap at 50 people, not 50%, but 50 human beings max. And that could be some tiny little mall or just tiny little church in a strip mall. It could be a giant cathedral. It could be a huge mosque. It doesn't matter. 50 people strictly across the board. So this was actually, it was unique to the lawyers, I guess, in a procedural sense, in that this was actually a very quickly decided case because it was a temporary restraining order. This church wanted an order saying, like, hey, you Nevada cannot enforce this 50 person requirement when there's a different standard used for secular buildings. And that quickly got up to the U.S. Supreme Court. And unfortunately, the U.S. Supreme Court said, no, that's okay. And oddly enough, it was just a one-sentence affirmation of the lower courts upholding this 50-person rule. But it was notable that there was several quite interesting dissents. And this was a 5-4 decision. It was pretty controversial even among the justices. And Kavanaugh laid it out pretty clearly, I think, in that, why is there this double standard of that secular institutions are allowed to have hundreds or even thousands of people, whereas religious buildings, houses of worship, they're held to this double standard, and doesn't that violate the First Amendment?
What was the line from Gorsuch's dissent? It was the court would have Caesar's palaces treated above Calvary Chapel, or
exactly.
I have that
Caesar,
quote
right?
because I wanted to make note of that quote. It says, "The world we inhabit today, with a pandemic upon us, poses unusual challenges. But there is no world in which the Constitution permits Nevada to favor Caesar's Palace over Calvary Chapel."
Exactly.
And that's so interesting to me. I mean, I actually think that this is going to be, and this is a case that not a lot of people have talked about. And I think that this is a really important case to come out of this term. And I think it's probably because it was just denying some form of interim relief. It was, that initial restraining order. But you have a dissent from Alito that's joined by both Thomas and Kavanaugh. You've got a separate dissent by Gorsuch, which is one paragraph, and basically just says that. And then you've got an additional dissent by Kavanaugh. And what Kavanaugh does is he goes off of the Alito dissent and then applies the kind of standard tiered form of scrutiny that we would see in a First Amendment case. But Alito focuses really heavily on the discussions that a lot of us have been having with each other and in public and outside of being an attorney. But he specifically calls out the fact that the governor of Nevada endorsed a series of protests that were going on at this time, participated in a series of protests that were going on in this time, and then also had an order saying that only 50 people could be in a house of worship. So Alito goes very clearly at that specific line, which is something that I think has upset a lot of people when talking about these COVID orders. And I think that it's really important that at least one of the justices, joined by two others, joined by Thomas and Kavanaugh, are, pointing these arguments out and calling into question this unfair treatment of houses of worship during this time. So I think it's a really important opinion or dissent, and I don't think it's getting a lot of traction.
Yeah, I'm curious, what do you guys think, what kind of impact is going to have on how these sorts of cases develop in the lower courts? Because what we've seen thus far, because there's been, I don't know how many hundreds of COVID-related lawsuits filed, we've seen a pattern start to develop where there's a handful of types of cases tend to win and other types of cases tend to lose. The courts are very uncomfortable saying how much is too much, but they tend to be much more comfortable talking about procedure and structure. So one of the classes of cases that have actually done fairly successful in the lower courts have been these sort of, you're treating like parties differently, particularly in the context of churches. So I'm curious if the lower courts are going to see this as a signal and start ruling the other way on those.
Yeah, I really wonder if this case turned explicitly on it being interim relief. So what that basically means is that they were looking to stop the COVID. The church was trying to stop the application of the COVID order to them as a house of worship while they appealed the case. So while they went through the federal court procedure. Federal court cases can take years to make their way from the beginning all the way to the end up to the Supreme Court potentially. So I'm curious if this case really did turn on it being an interim question. And I do wonder what the breakout would be or what the opinion would look like if this was a final decision on the merits. You've got the four more conservative leaning justices all issuing some form of opinion here. So I think that there's something there. And I wonder if we'll see that in the future.
I think it was also especially noteworthy that there was kind of a backhanded jab at, I think, was it the Jacobson case?
The Jacobson case.
Basically, they made a backhanded jab at the infamous Korematsu case, the case from World War II that authorized the internment of Japanese Americans in concentration camps, and basically stating we Americans all know that was a pretty horrible thing to do. So when there's just a very general public sentiment of that a law or a policy is unjust or hypocritical, that the court needs to actually show some backbone.
Yeah. And for you guys who aren't aware, is Jacobson is the Grim Reaper specter hanging over all of this.
Yeah.
That's a case from 1904, 1905?
I don't recall the year.
It's early. 1905.
Yeah.
Immunization case, right?
Right. That was the case. And basically, anytime you have a court that's saying various COVID-related restrictions are constitutional, they're usually hanging on that case. So that's the dead hand of.
It was a case dealing with mandatory vaccination, essentially, and Alito makes a very clear point of distinguishing that case from the COVID-19 scenario. So I think it is possible that because a lot of people have been talking about the Jacobson case because it's become the North Star for a lot of people in this conversation. But, Alito has kind of started the process of distinguishing that case. So I think it's very possible that if one of these cases goes up on the merits that, a majority could easily distinguish Jacobson then from this scenario. But let's go ahead and jump on to some of the major opinions that the court issued. And the three cases that I think we're going to focus on are very hotly debated cases. They're also generally outside of Mountain States Legal Foundation's issue areas. We pay attention to what the Supreme Court is doing because we see that as the ultimate destination for all of our federal litigation. So we're very familiar with these cases. But they definitely are in areas that we don't normally talk about. But what we really want to offer here is a different conversation. A lot of people are talking about the outcome of these cases and are looking at the inevitable decision. But I don't think a lot of people are focusing on how the court got to those decisions. And so I want to focus on that portion of the conversation. The justices are sparring with one another. And this certainly isn't uncommon, but it seems to be almost in a theme of the term. And we're going to get to a theme, our overall takeaways at the end of this, but it really does seem to be a theme here. And the key here is that results are important, right? Mountain States Legal Foundation, we advocate for founding principles. We are fighting cases in federal courts and state courts because we want to support the founding principles and we want to uphold and defend the Constitution and our republic, right? The process here is interesting. Because if we know the process, then we know what the result will be, or we have an idea of what the result will be and how we can get to that point. And I think the key here is in a lot of these opinions, what we're dealing with battles between originalism and textualism, but just different interpretations of those same thing. And these are conversations that the Supreme Court wasn't having 40 years ago. I mean, Scalia really brought this to being a forefront of court decisions, to the point where when textualism was taught in my law school, it was taught as Scalian textualism. So this is a very new conversation for the court to be having. The battles between justices aren't new, but the type of battle is. So with that, we're going to go ahead and start with Bostock. And I'm not sure if it's Bostock or
Do we want to, before really quick, just go into originalism and textualism, what these mean? Yeah,
we can. So the idea here is originalism or textualism is basically interpreting the actual text of the law or the statute or the Constitution that's at issue in the case, and then looking in to see what that text meant when it was drafted. Now, there's some debate over whether you should look at a strict dictionary definition. Should you look at how Congress or the drafting body thought what those words meant? Or should you look at the original public meaning of those words? And a lot of originalism has now leaned towards original public meaning because that seems to be the most appropriate way to interpret the Constitution as well as statutes at the time. But that is a very nuanced debate that we haven't really seen a lot.
Yeah, this is new. It's really interesting to see is what used to be debates between the living constitutionalists and the originalists. Living constitutionalism has largely gone away, at least publicly. It's still going on the surface, but no one admits to it anymore. So now what we're seeing arguments over different schools within originalism in a way that, like you said, we didn't even see even like 20 years ago. We didn't even see really a whole lot of.
So in Bostock, this is the Title VII case that dealt with people being fired based on some considerations of sex. But the important thing here for me is we have three separate opinions. So it's a 6-3 majority. Gorsuch writes the opinion for the majority. And then there's a dissent that's drafted by Alito, and there's a dissent that's drafted by Kavanaugh. So all three of these opinions are all textual interpretations. They all come out to a different result, but they are all textual interpretations of Title VII and dictionary definitions, original public meaning, congressional meaning. And to see that being the conversation that the court is having is that exactly this idea that we're now talking about dueling textualism. I know that the inevitable result has a lot of debate surrounding it, but really looking at the way the court got there. So Gorsuch focuses in the majority opinion on this hypertextualism mixed with formal logic in a sense. And that's the easiest way that I can describe it. So basically Gorsuch is looking at the word, defining it out of the dictionary, and then using that, formal logic construction that we've all forgotten from high school or college of A plus B, therefore C. So Gorsuch is just really narrow on his interpretation. Alito, in his dissent, also using textualism, looks at the original public meaning of the words, looks at what Congress was talking about, the conversations that Congress was having after Title VII was drafted, and uses that to inform his analysis. And Kavanaugh looks at a little bit of textualism, but I actually think Kavanaugh's opinion might be the most interesting from a boring legal scholarly opinion, but I think actually has the most effect for everybody sitting at home too, or at work, wherever you're sitting. Kavanaugh's problem is that the justices aren't a legislative body. Kavanaugh draws a specific distinction to, we decide cases and controversies, we don't legislate. And he kind of calls out the court in a sense a little bit he basically accuses the court of acting as a legislative body in its decision. So I think it's really interesting. And Kavanaugh quotes some of the Federalist Papers for this. He quotes back to some original writings. So he's doing this form of originalism through what the purview of the Supreme Court is. So not only do we have a textualist battle, and I'm smiling, I know that I'm geeking out very hard, so I apologize, but we have this textualist battle going on, and then we also have this hearkening back to the original jurisdiction of the court. And I think that's a really important takeaway from an opinion that everybody has been focusing on the outcome.
Yeah, and I think it's really interesting in the especially, so I focus mostly on Alito and Gorsuch's opinions, less so on Kavanaugh's. I guess it was the second dissent. But something I was really interesting is both sides kind of can come from this perspective of saying we're the narrow minimalists on this, because from Gorsuch's perspective, you can say, hey, it's not the court's responsibility to fix Congress's messes. We look at the text on the page. We try to divine what was in their heart of hearts. We look what's on the page. Congress said on the basis of sex, we go through the process. That applies to gay individuals, transgender individuals. Therefore, that's what Congress did. They can change it if they want to. Meanwhile, Alito comes at it from the exact opposite. He says, well, we don't have the responsibility to fix Congress's mistakes. We also don't have the responsibility to update old laws for modern sensibilities. And depending on kind of how you're looking at what they're doing, how you describe it, how you see it, it's really interesting is both arguments can be seen as the humble minimalist opinion, depending on how you frame the argument, which I think is really interesting.
Absolutely.
I think we'll see these battles going a lot more. So as we keep moving into these cases, I should make note, we'll have a question and answer portion here at the end. If you look at your screen at the very bottom, there's a place where you can go ahead and click Q&A. You can submit questions. Once we finish getting through some of the major opinions and our takeaways, we're happy to answer those questions as best as we can. So feel free to start putting those in, and we'll start filtering them so we can go and answer them towards the end. So after Bostock, we had the major opinion coming out, Department of Homeland Security, the DHS case. And this is the one that deals with the DACA question. So David, do you want to talk about that one?
Yeah, so this is a bit of a trip down memory lane for the last few years. If you recall, the Deferred Action for Childhood Arrivals program was a program that the Obama administration had attempted to shepherd through Congress, got shut down, and then decided to issue it as an executive order. This was basically saying, as my duty as chief executive, I am saying that we are going to prioritize certain types of immigration enforcement in order to prevent, or we're not going to prioritize people who are brought over as children, students, stuff like that. This was a whole legal battle during the Obama administration about whether or not he could do this. Eventually, the administration itself came out and said, yeah, we don't have the power to do this. Fast forward to the Trump administration, which is a different administration with very different goals, particularly on immigration, to say the least. So what you have is Trump then rescinds the DACA program, and that decision gets challenged. So those who've been recipients under DACA say, hey, regardless of whether this was legal or illegal at the time, it's arbitrary for you to take it away from us now because we've been living under this situation for years. We've developed reasonable expectations about what's going to happen to us. We've built a life here. And what the court said eventually, their decision in this case is that while the Trump administration would have had the authority to rescind it, that's you live by the pen and the phone, you die by the pen and the phone, except for the fact that it didn't adequately explain its decision. It said, you made a decision, you try to come up with some post hoc rationalizations later, but you have to consider the reliance interests of those who are going to be affected by your decisions. Fair enough. This all sounds fairly reasonable until you go back and you remember that the initial DACA proclamation didn't involve any sort of administrative procedures at all. So this is a case that it deals with what we've come to call the one-way ratchet. So there's a situation where the Supreme Court has basically endorsed a system where it requires less effort to create a policy than it does to rescind that policy, which means that any president, including President Trump, if he so chose, could, at least theoretically, based off of the DHS v. Regents case, come in literal 11th hour, January 19th, before they're kicked out of office, issue a whole lot of executive orders that probably unconstitutional. They obviously don't have the authority to do, but they create potential reliance interests, and then it becomes very, very difficult for a later president to rescind that. And this has very broad implications beyond DACA because the actual factual outcomes of this case probably not going to be all that significant because everyone acknowledges that Trump administration can rescind it if they so choose. They just have to dot their I's and cross their T's, which they didn't do. So in the long run, this probably isn't going to change the policy on DACA all that much. But what it does do is it endorses this one-way ratchet. And it also, in some ways, endorses the idea that you can, in fact, get what's known as estoppel against the government. It's in the context of administration, this administrative law. This gets a little bit technical. I don't want to get too into it. Yeah. But there's long been a debate about whether you can get what's known as equitable estoppel against the federal government. That means a judge can declare something was unfair, manifestly unfair, what was done to you. Usually you can only get that against the private party. This kind of confirmed you get that against the feds.
And I think this is the opinion of the term that is, regardless of policy, regardless of the factual scenario, regardless of the outcome, the process here is endorsing something that's universally bad. I mean, the idea basically that it's created is that one-way ratchet that David's talking about. Basically, any administration can issue a policy at the very end of its administration, and if it creates any form of reliance interest, the next administration has to go through a long, complicated process to try to rescind something that could have been just drafted on a sheet of paper in an executive order.
And this is something, probably to bring it closer to home, something that probably people have thought about more often, something you might have heard is that a lie travels around the world 3 times before the truth can put its pants on. This is a similar kind of situation. It takes very little effort to make these policies and a great deal of effort to rescind them in a way that you get a one-way ratchet.
Yeah, exactly. Yeah, I think this one is going to be really interesting moving forward because this is going to be the opinion where people are going to like the outcome, but then when they learn what the process means, they're not going to.
Well, the fun thing is it's probably beneficial for one of our cases and probably really bad for one of our other cases. So what's interesting is like, regardless of what your policy ideas are on this, the legal issue matters because it affects different people on different sides of the political spectrum in kind of unexpected ways.
Which I think actually brings us nicely to the Mcgirt case coming out of Oklahoma. This is the one that's dealing with the Oklahoma Indian treaty rights. My general disclaimer here is going to be Indian treaty rights. Those are specific terms of art that we use in the legal world. They have a very strong legal meaning when we talk about them. So that's why we're using those terms in particular when we're talking about, these treaties and the different groups of individuals involved. But Brian, why don't you go ahead and bring us through the Mcgirt case?
Yeah, you bet. So as Cody mentioned, this is a huge case. It's probably the biggest case in Native American law in living memory. It's huge. And it centers around something that sounds kind of abstract and dry, the issue of jurisdiction of Indian tribes. And even though it sounds abstract, it actually has a lot of very significant real world impact. And tribal law, it's a very complicated subject. To give a very, very, very brief overview of the issue here, as most people know, Indian tribes or most tribes are their own nations, but there's kind of a big footnote there because the federal government intervenes significantly in a lot of their affairs. So jurisdiction is just the legal term for which court, which entity gets to decide what. So some cases are for states, some cases are for the federal government, some cases here are for tribal courts because they're separate states, there's separate nations, they're separate governments with separate courts. So for instance, a divorce between two members of the same tribe would be a purely Native American matter. Feds, states wouldn't touch it. But in other cases, the feds do get involved. And in this context, we're dealing with criminal law. And this has actually been a pretty ancient policy, at least ancient by American standards. Ever since the 19th century, there have been federal statutes in place saying that in certain cases of very serious crimes like murder or kidnapping, that kind of a thing, a member of an Indian tribe may be tried in federal court for that crime. And there's exceptions, this and that, but that's the essence of it for our purposes here today. So what happened in Mcgirt is that Mr. Mcgirt in 1996 was convicted of sexually assaulting a child, and he was tried and convicted in Oklahoma State Court, not federal court, but state court. Mr. Mcgirt is a tribal member. So Mr. Mcgirt appealed in federal court saying, hey, this should have been a federal matter. I shouldn't have been tried in state court to begin with. What the heck? So ultimately, decades later, the Supreme Court in a very narrow 5-4 decision actually agreed. And again, this was premised on jurisdiction. The Supreme Court said that Mr. Mcgirt should have been tried in federal court under one of these 19th century statutes saying, the Major Crimes Act, saying that, in this case, sexual assault should have been a matter for a federal judge to decide. And the reason why it's so momentous is that it really expanded the reach of jurisdiction for tribal matters, particularly in Oklahoma. And kind of an interesting historical side note here is that, as a lot of people know, Oklahoma used to be called, again, direct quote, Indian territory. It was specifically reserved for 5 tribes that used to live in the eastern United States, and then in the infamous Trail of Tears, they were forcibly removed to Oklahoma. So several decades after that, Oklahoma suddenly became a state in 1907. Well, to make a long story short, what the Supreme Court case hinged on was the court's determination that the act of Congress that made Oklahoma a state did not specifically de-establish these Indian reservations in what is basically the eastern half of Oklahoma. So like the Cherokee and the Choctaw, they had these huge swaths of land that were reserved for them ever since the early to mid 19th century. And Justice Gorsuch said that, well, because the Enabling Act that made Oklahoma a state didn't specifically remove that, those original boundaries for the purposes of criminal law only, those still exist. So basically, all of eastern Oklahoma is still subject to tribal court jurisdiction, which meant that Mr. McGirt's conviction had to be remanded back down to be decided by a federal judge.
Yeah, I think this is actually so. This is universally the opinion that I saw a lot of people coming out on with very bold kind of viewpoints on the inevitable decision of, half of Oklahoma now belongs to a tribe. And so I think this is kind of universally, I saw a lot of bad takes about this. I also have a very narrow view of how this opinion is going to come out. The tribes in Oklahoma are very different than a lot of tribes across the country too, right? They're in a very different scenario. They didn't have the pure reservation system that almost every other tribe has. They had a different system where they were granted land patents, and those kind of all were within the purview of the tribe. So that factually sets it apart very differently, I think. Also, all that the court is really saying here is that criminal prosecutions in this territory are subject to, federal prosecution, not state prosecution. Now, I could certainly understand why Oklahoma is concerned about its sovereign territory as a state, right? Its ability to enforce its criminal law within its own state. That's definitely concerning to Oklahoma, and I can certainly understand that. I don't see this blowing up to be a major opinion that has a big effect in the future.
I think the direct effects are going to be fairly minor. I think as a practical matter, what's going to happen is because this really unsettled a lot of expectations. These are big questions. There's millions of people, maybe there's 1.8 million people, I believe, living in this area, most of Tulsa. So what's probably going to actively happen is that there's going to be some sort of mediation between the tribe and the state and the federal government that's going to come to some sort of mutually amicable compromise. Mm-hmm. So for this particular case, I don't think there's going to be significant practical implications. I do think that there are potential implications that you're kind of shortchanging. I do think we have to wait and see what kind of impact this is going to have on zoning law, certain family law and divorce law situations, schooling, taxes. I think there's a lot of implications here that may not. And but again, I think this is another very interesting case, in that it's another disagreement between the members of the conservative wing of the court. Is you have Gorsuch writing the opinion for the majority, and you have Chief Justice Roberts writing the chief dissent. And so I think that's another really interesting thing is how we're looking at this. I think another thing important to realize in Mcgirt is that how incredibly messy and different Indian law tends to be from the rest of American law. Mm-hmm. So, for example, all sides of the court were operating under the assumption that certain earlier court cases were legitimate. One of those is a court decision that says Congress doesn't have to actually follow through on its treaties. It's perfectly capable of going against its word with the Indian tribe. No one has any sort of remedy for that. That's a decision everyone kind of accepts.
Yeah.
So there are interesting cases where no one really is operating from first principles, which gets a really complicated situation here.
Yeah.
So this, within the office, there's a lot of debate about what the proper decision would have been.
Mm-hmm. And this is because this is exposing something different, right? This is exposing the idea of when the justices aren't operating on first principles, when they aren't operating on these clear methods of interpretation, originalism and textualism, which are so important, that it's a lot tougher to see kind of where it goes. And it's going to, I think your interpretation is fair. You never necessarily know exactly how these cases are going to be cited in a brief in 20 years, but I think this one's pretty limited. But with that,
well, this case is fun too, because I think more than any other case on the docket this term, this case depends on your understanding of the factual background. You read Gorsuch's description of facts, and then you read Robert's description of facts. They seem like two entirely different situations. Right. And it's kind of a situation where you read Gorsuch and you're like, this makes a lot of sense that we're going to hold Congress to the terms of the deal it engaged in. And then you read Robert's opinion, he says, well, it's a little bit more complicated than that.
Yeah.
And so I think, again, this is another important thing I think a lot of people don't necessarily understand about court decisions and stuff. And a lot of times the facts and how they're presented are significantly more important than the rule of law.
And talking about Gorsuch and Roberts, I think brings us nicely to our general takeaways. I see some questions are rolling in. Here's your reminder. If you've got any, go ahead and put them in there. We'll get to them shortly. I know that people want to ask us questions because I know that nobody wants to sit here for 50 minutes and listen to attorneys ramble. So, but with that, and since we're where we're at on time, I want to get to our major takeaways from this term. So I want you to have one major takeaway, and I want to focus on that specifically so that we have time to get to questions. So I'll start with Brian.
I think the biggest one that we've been talking about throughout most of this is just what is textualism today, because it's changed so much in very recent years, as we've just been, is it Gorsuch's definition, is it Alito's definition, and we need to figure out what the rules are to figure out how the game is going to be played, and it's an exciting time for a constitutional lawyer, I can say that much.
Right. I think we're seeing a lot of people for a long time assumed that originalism was much more monolithic than it is, assumed it would result in much more predictable outcomes than it ended up has.
Right. Yeah, I mean, you've got this battle between hypertextualism versus original public meaning versus...
Kavanaugh's got his text history and tradition.
I love Kavanaugh's text history and tradition, but that's my inner gun rights Second Amendment attorney talking. But I do think that that's really interesting, and I think we're going to see a lot more originalist, textualist battles. I mean, you're seeing cases come out on those grounds specifically. So I think we're going to see that a lot more often, and it will be interesting to see kind of the justices' different reasonings.
Well, particularly Justice Kagan on the left has really embraced originalism as a way of like, okay, we can't beat them, join them, sort of thing. So I think that's really interesting too. And you see kind of Kagan rising up and being sort of the Roberts kind of equivalent, almost like the shadow chief speaker, or like the opposition, leader of the opposition, I guess.
Yeah, and remember, there is such thing as bad originalism. So, David, with that, what's your major takeaway from this term?
On a very similar line, I think the main takeaway here is this term is where, I guess, for lack of a better term, we've seen sort of Justice Gorsuch come into his own. Whether you like what his own happens to be or not is an interesting question, but before we always kind of saw as like, okay, he's an originalist textualist in the Scalia-Thomas-esque tradition. But I think this term is when we've actually seen the divergence between him and particularly Thomas and Kavanaugh and Alito in his more hypertextualist approach versus an original public meaning approach. And I think that's really interesting is that it's not inconsistent. I think you can see this, there's a through line way back to, which I think is interesting, is the frozen trucker case that was a big deal during his confirmation hearing that people were talking about was, he's going to side with the big guy against the little guy, which really that was a hypertextualist opinion. And it's funny, you see the same sorts of criticisms coming from the opposite sides of the spectrum on which is very consistent interpretation, but in a way that people weren't expecting.
So there's a quote from Gorsuch's opinion in Bostock. And he said, and I'll quote it for us, "When the express terms of a statute give us one answer and extra textual considerations suggest another, it's no contest." And I think that's exactly what you're saying. He is that hypertextual approach. His idea is, if I can derive an answer from the text and the text alone, I'm going to derive that answer.
Well, and this is where you think, this is where the power of a judge comes in. This is the power interpretation. This is where the discretion comes in.
Yeah.
Is the determination of whether the text is ambiguous or not. Because I think that's the major thing with a
lot of the opinions from the term.
So I think this is the major thing, is it ambiguous? So Gorsuch says in the Title VII context, he says, this is completely and utterly unambiguous. The text says this, it means this. It doesn't matter that no one in 1964 would have thought this was the answer. You look at Alito and he says, well, hold on for a second. This is far from this clear-cut thing that you're saying here. So a lot of the movement, a lot of the action is happening in that margin of, is this ambiguous? Because if it's ambiguous, the toolbox opens up. There's a lot of stuff you can do and a lot of mischief you can do. But then again, just declaring everything unambiguous, you get kind of the same result, because if you never find anything ambiguous, you get to be the one with the answer every time. So
I see that for my takeaway, we're going to go ahead and leave Cody with the Chief Justice, which is perfectly fine. I think the biggest takeaway, I think you're both right and you're both wrong, because the biggest takeaway from this term is, what is Chief Justice Roberts doing? I have seen a number of people try to justify his judicial philosophy. The closest that I've seen to has been judicial minimalism. This idea that Roberts has no interest in rocking the boat, that he's going to give a lot of respect to stare decisis, meaning previous decisions of the court, that he's not willing to have these earth-shattering opinions but I don't think that's accurate. I don't think that's true when you look at the opinions. There's plenty of times when Chief Justice Roberts has been okay with, violating the principles of stare decisis, and there's other times when he cites that as his authority. There's times when he's okay with earth-shattering opinions and times when he's not. I think the biggest takeaway, and the only thing that I can possibly figure out from Roberts in this context, is most of the big decisions from this term that we would not expect, that people coming into this term would not have expected with what we would call a conservative-leaning majority, is in those cases that wouldn't fall necessarily under that mindset, the opinions, while they may be earth-shattering, are very limited. So the one-way ratchet is the scariest for me, I think, this idea. But even then, it's a very limited opinion. It basically says, if you want to repeal, you can. You just have to say why and go through a bit of a process. And I think all of those opinions have that in them. So I can completely understand why a lot of people are very frustrated with Roberts right now. The frustration a lot comes from just not knowing how he's deciding cases. I mean, we can point to the philosophy of the other justices. It's tough not being able to point to his philosophy. I think a lot of it is he is kind of undercutting the opinions in a sense by taking away a lot of what we as attorneys would call the precedential value. It's what we would cite a case for as a precedent moving forward, as establishing a solid legal principle. And I don't know that there is a lot of really solid, earth-shattering legal principles that came out of this term. There are some, but I don't think there's a lot.
No. Yeah, and I think that's one of the questions we were asked was who's the most unpredictable justice? And I think by far that's easily Roberts.
Yeah, for sure.
I think that's the situation where we're trying to figure out what he's like. My uncharitable interpretation would be that he has a have your cake and eat it too interpretation, because that I think is most obvious. I think one of the cases we didn't really discuss is the CELA law of the Consumer Finance Protection Bureau, which is a case where no one got he tried to make a compromise and everyone hates him for it. So this is a situation where the Consumer Finance Protection Bureau, this is Elizabeth Warren's baby, independent agency, had sort of specific rules about independence from the executive branch, the president and chief executive. So the court overturned its decision for how the director is decided, is determined, whether they can be removed for cause or for any reason at all.
Yeah.
So he removed that, which was a win for the conservatives. But at the same time, he agreed to sever that portion of the law from the rest of the law, meaning the rest of the Consumer Finance CFPB. It's much easier. The rest of the CFPB stands, which is something that I think is a big deal in this case, because what he basically, which is effectively rewriting the statute, is you're assuming that Congress would have preferred this version without their independent control over nothing at all, which I think is an assumption that cannot be made. And that's a problem. That's similar to kind of what happened with the ACA case, where the Obamacare case, the big one, there's been a few. But the big one, and that's the thing where, again, no one was really happy with him because he kind of split the baby, not realizing that parable is about splitting the baby's the wrong decision. he actually did it. I mean, everyone's happy, right?
Sounds like me when I tried to decide where we go to lunch. When nobody ends up happy.
So you get this situation where he's very much an institutionalist. Yeah. And he cares very much about some sense of legitimacy of the court.
Yeah.
Exactly how he determines whether it's legitimate or not, I have no idea. But he's clearly concerned as the Chief Justice with the legitimacy of the court. And I think by so carefully trying to manufacture that, he's having the exact opposite effect, because everyone can see that this isn't consistent.
And I think we've got pretty clear philosophy. So Thomas is obviously, we know exactly where he's going to, And Thomas remains, you know, the hero of this term, always having the right opinion at all times, it seems. And not just because he has the right opinion, but because he ties it back to foundational principles.
He was wrong on CELO.
Oh, okay. He ties it back ordinarily, 99 out of 100, ties it back to that foundational principle, ties it back to constitutional originalism, looks to founding era sources. So we know him. Alito has kind of come into his own this term, and I really think it's in a response to Roberts. Alito is throwing punches. He is calling out the court left, right, center. He doesn't care anymore. Well, I'm sure he still cares, but he is not okay with the direction the court is going, and he's going to make it known. In law school, everybody loves reading the Scalia opinions because they're very readable, but because they're also kind of in that sense. I think the next series of Alito dissents opinions are going to be that. I think they're going to be very readable. I think they're going to be very interesting. And I think he's going to be throwing haymakers, verbal haymakers, in his opinions going forward. But yeah, I think Roberts is absolutely the most unpredictable.
Talking about, okay, because we've mentioned both kind of Gorsuch and Alito both coming into their own. We talked a lot about the court's concerns. We haven't really talked about the court's left wing this term. And it seems, when I was thinking about it, I realized we weren't talking about that. I'm wondering, it seems like they kind of sat this term out.
Yeah.
They were kind of happy to let Roberts take the reign on the controversial decisions, which I thought was really interesting. They seem to consciously take a back seat in certain ways, which I'm curious to see if that's going to be something that we can see going forward.
Well, I think part of that too is in those majority opinions. So when Roberts is in the majority, he gets to decide who writes the opinion. So in a 6-3 case where Roberts is in the majority, he can assign the opinion to whomever he wants, and he assigned it to Gorsuch in a couple scenarios. So I think you're right. We're talking about what everybody thought was going to be kind of like a bulk kind of conservative leaning majority, and that term didn't play this out at all. And I think a lot of people are going to be paying a lot more attention to judicial philosophy over judicial decision making, especially in the nomination process.
We're starting to see basically a 3-wing court. You have the committed progressives, which is Ginsburg and Sotomayor.
Yeah.
You have the institutionalists, which are Roberts, Breyer, and Kagan.
Yeah.
And then you have the originalist conservatives.
The
ideological conservatives, which is led by Thomas, Gorsuch, Kavanaugh, and Alito.
Yeah.
Because I think we're kind of seeing this kind of development of kind of a 3-wing court.
Yeah. So going to one of our other questions, someone asked, when it comes to the issue of due process, are there any cases on the horizon that deal with private property rights? There are a few going up. There was a couple decisions out of this court that were fairly benign, dealing with property rights, nothing that really is going to be earth-shattering. There's a couple petitions coming up dealing with, there's a few cases that are resolving their on the merits at the circuit level and could go to the Supreme Court. The Supreme Court's going to have to look at. I think the big one is going to be in the takings context, because there is no consistency when you're talking about takings. And what takings is this question of when the government takes your property, takes beneficial use of your property, removes any monetary value of your property, are you entitled to just compensation in those scenarios and how that plays out? And there's a couple cases I've seen starting to square up petitions for cert to get their issues before the court dealing with takings. And I don't think anybody's happy.
The court hasn't given a whole lot of indication that it's willing to do anything.
Yeah.
Takings law is one of those areas where there was a lot of activity in the early to mid 90s with the Rehnquist court. And that's where you get that's where you get the Commerce Clause decisions.
Yeah.
But especially in takings too, you get the Lucas decision. That's the first time you start seeing regulatory takings actually being enforced. But then the court hasn't really done anything with that in
It'll be interesting
10, 15 years.
Yeah.
And just last year, they turned down a couple really good cert petitions. There's one really good taking cert petition that just got filed, actually, to your point, that I think might have a good chance of getting called up.
Mountain States has been filing briefs in support of that case for a while.
It's a PLF lawsuit that we've assisted with in briefs.
Well, and so the other thing is, do you think that there's any of those natural resources cases that are squared up? I mean, some of them are a little early.
I think it's too early to tell, unfortunately. I wish it was otherwise, but there's still got to be so much development, I think. I think the big development in natural resource laws will be more on the administrative line in terms of trying to make our case, the win in Kaiser v. Wilkie.
Mhm.
That's probably going to be the biggest line of attack for natural resource cases, but I would love to be able to have more of a takings line of action too, because that whenever somebody contacts us about, I just got my life ruined by the Forest Service or the BLM or something, it's like, can I pursue a takings claim? I was like, I want to say yes, but oftentimes I can't say so.
I think we've all seen both on the Supreme Court and in the lower courts the last couple of years, and this is part of a reaction to kind of the Trump administration's kind of fly by the seat of the pants style, is I think we've seen a greater interest in the administrative process, dotting the I's, crossing the T's, and how that violates rules of due process for those who are being regulated. So I think we're likely to see significantly more cases going in that direction, where we're finding if the government's going to, especially when they're rescinding things, because that's how it works. I think
I'm going to cut you off there because we're almost getting to the end. And there's actually one question that I quickly want to get to. Everybody's going to get a 2-sentence answer to this question, and then we're going to go ahead and wrap it up. So the question is, how might a vacancy affect the current balance of the Supreme Court?
Whose vacancy?
See, I think that's part of the problem.
Right.
So you get 2 sentences. What do you think?
Oh my God.
Okay, I'll go first.
So much, it depends on the
I can go first.
Election?
I think a lot of it's going to depend on the election. A lot of it's going to depend on who the vacancy is. I think if you have one of the more conservative-leaning justices retire, I don't think you're going to see much change. I think if you have one of the more progressive justices retire, it's more likely that there's a shift, because then there's a different kind of balkanization. I think that 3-wing court is going to come into a lot of play there. The only thing I don't know is I don't know how the chief will respond when the cases from the administration are coming from the other perspective, if there is a shift during the election.
Okay, I got my answer.
Okay.
Figured it out. The answer is that the days of Merrick Garland nominations are over.
Yeah.
That we are no longer going to get restrained, respected by all sides, administrative law judges.
No.
We're going to get bomb throwers in the Scalia mold. I think that's on both sides. I think both sides have decided we're done with appointing the most boring jurist we can think of. We're going hard on the culture war. I think that's what we're going to see a lot of that.
Right.
I would basically just echo David's comment, but my sentence would be that stare decisis is going to get less deference, I think, in terms of just that some of these apparently set in stone decisions from decades ago, they actually might get revisited. Just given the whole new landscape that we seem to be dealing with, at least on a couple of fronts.
Yeah.
Maybe I'm just being optimistic.
No, I think that'd be interesting. And I think we could talk about the topic forever, but we don't want to keep you guys any longer. We will certainly be doing more webinars discussing Mountain State's cases and Mountain State's issue areas, and we'll be looking at some of the outcomes going forward. So thank you guys so much for joining us. We really appreciate it. Again, if you want to learn more about Mountain State's Legal Foundation, go ahead and visit us at our website, mslegal.org. Go ahead and follow us on social media. We have a Twitter account. We have a Facebook that are both pretty active, and you can see more about our cases there. I would encourage you to go and look at some of the cases that we're fighting on behalf of our clients, where we're litigating against the government, who is just a behemoth. And individual people just can't stand up to the federal government sometimes. And that's where Mountain States comes in. That's why we're here. As much as we enjoy sitting at a table talking about the Supreme Court for an hour, what we really love doing is fighting for the everyday Americans against the behemoth that is the federal government and upholding those constitutional principles. So I'd encourage you to go learn about some of our cases. I'd encourage you to go ahead and follow us. Go ahead and donate if you're interested in supporting our cause or supporting any of our clients. And if you have any questions for us, feel free to reach out. Our contact information is on all of those. So thank you so much for joining us, and we hope to see you at our next webinar.